The DA says the court should not allow the seizure of Tshwane by force, saying it harms the rule of law. The DA, the ANC and the EFF are heading for a showdown in the North Gauteng High Court over the removal of Speaker Katlego Mathebe and Mayor Stevens Mokgalapa. The court action is centered on a council meeting that saw the ANC and economic freedom fighters vote together to remove the duo.
If we are elected out through lawful means, and I want to underscore lawful, then we will accept that without a doubt. Now here's the thing, it was unlawful. If we start to accept unlawful December, ourselves against such unlawful behavior in a future case, we can't if we just stand back, because we said, well, on the 5th of December 2019 you guys were happy with it. Now in this matter you can't, and that matter might be incredibly important for the entire South Africa. Rather we stand on principle, rather we stand on the rule of law, and that's where we are. And who knows, the next council meeting, maybe there's a different EFF that arrives. You can't say that it's it's going to be one way or another, but I think you must say that you must stand for the rule of law. Things must be done lawfully. Things must be done as per the Constitution, and that's really what we're appealing to. And we think the judge will hear us.
For the latest on these hearings, let's cross over to our reporter, Hitekani Magwedze, who is in Tshwane at the moment. Good afternoon to you, Hitekani. Why don't you give us a bit of an update? I see you've adjourned perhaps for a bit of a tea break there, but give us an update as to what the highlights have been so far for this morning.
Certainly, Tammy, the adjournment is, of course, for a lunch break, and the proceedings have been taking place from around 10 or just after 10 o'clock this morning, and they have been started with the legal representatives of the mayor, the acting mayor, and the speaker of Tshwane, and the DA legal representative as well. And the reason I cluster them together is because obviously their arguments are quite similar, and they follow the same type of vein and the same purpose and desired outcome, and that is, of course, for the resolution of the 5th of December to be set aside and for a review to take place. And the intention of that is, of course, for the DA to reclaim and sustain the claim to the Tshwane. And the argument is that the speaker and the deputy speaker, rather, we know that on that day the speaker apparently recused herself from taking place in the session because of the motion of no confidence that was set against her. What the DA is arguing is that when that happens, the deputy speaker in Zweli Khumalo is supposed to take his seat and preside over whatever session is going on or whatever points are on the agenda. They're arguing that the deputy speaker was not allowed to do so. In fact, they're also arguing that the municipal manager, who apparently falls under the deputy speaker in terms of someone who's supposed to take the seat after the deputy speaker, was also not allowed to take his seat. And this is why the DA has continuously been saying that the ANC and EFF are trying to take the Tshwane Metro through a coup. We know that there was chaos at that council meeting on the 5th of December, but the ANC coming back and saying that the DA is jumping the gun and that there are processes that can be followed under council to resolve this matter, saying that, in fact, warning the judge that if he does intervene or intervene in political matters that are not judicial yet, he would be compromising the integrity of the judicial system. Is the legal representative of the ANC arguing that there are steps that are available for the DA to follow before it actually comes to court. He says this is at the moment not ripe enough. It's still political, and it's not supposed to be entertained by the judicial system as yet. He's also really arguing that the DA still has processes and steps that they can follow. But another thing that's important, Tammy, which we found while speaking to the chairperson of the DA in the province, Mr. Mike Moriarty, was that the DA is actually hoping for a win here, so that when they sit in council the next time they actually do, they can try and convince the EFF to side with them. We know that as of a couple of months ago, the DA and EFF haven't really been getting along. So on the 5th of December, whether legal or not, stall that while they try and convince the EFF to back them so they can win over Tshwane.
Quite interesting there, Hitekani. Did the judge comment on, whether or not it is proper for the DA to have taken this case to court? What was his reaction to the ANC saying that there are other due processes that should have been followed within council before actually approaching the courts?
Well, Tommy, the judge has been quite interactive throughout this morning with the different legal representatives, asking very pertinent questions and really poking at the arguments that have been brought forward by the legal representatives. But on the matter of his jurisdiction, he's been really trying to find clarity as to what the argument of the ANC is. And there the ANC saying that at the moment this matter is really political, and it's important to maintain the integrity of the judicial system, saying that if this judge allows or rules against the ANC or rules on this matter entirely, on the urgency of it even, it will open up the floodgates for other politicians and other leaders who fail to follow due course and due processes within the organizations or whatever sitting to try and resolve those matters in court without following the due processes within the set organizations, warning that this will, compromise the integrity of the court. He's been really repeating that quite a lot, but the judge hasn't really entertained that or given his thoughts on that matter. We do understand as well that the judge will probably make his judgment in writing, and it might not be given today, but that's still quite speculative, so we will be waiting until the end of the day. Of course, there are other matters that will be addressed later today. Just one last thing, that the ANC was arguing that the founding affidavits of the DA were made by a witness who was allegedly not inside council. So the ANC is, on top of the jurisdiction argument, is arguing that the DA's founding affidavit, which is the foundation, if it were, in court to their case, is flawed, and therefore there is no case that the judge should be listening to.
Thank you, Hitekani. Before I let you go, what ought we to be expecting after this lunch break?
Well, we're expecting the legal representatives or the lawyers of the ANC to continue in their argument. We've heard from about 3 or 4 lawyers already representing the multiple respondents and applicants in this case. We also expect that the EFF's lawyers will be taking to will be standing up to make their arguments. So that is one final step into towards hearing the judge and his reaction and what decision is taking, whether he is actually making a judgment today, which might just be extraordinary considering the amount of information and the amount of arguments that have been given and the amount of papers that have been submitted in terms of the affidavits and responding affidavits that have been handed over. So there is a slight or maybe just little expectation of him to burden himself in making a judgment today. We expect that he might just make his judgment later and in writing, but there is an expectation that there will be a judgment that will be handed down by the judge before the end of the year.